I have no contract or agreement in place. Can I still pursue a debt? What evidence do I need to have to pursue the debt? I've already agreed a different amount, but it's still not being paid. Can I still pursue the debt? When you're owed money, hindsight can be a wonderful thing. All too often, in the rush to complete a business transaction or lending money to a friend in need, you won't think to put in place a legally binding agreement that formalises the arrangement beforehand. After all, you have every intention of holding up your end of the deal and so assume the other party will too. But if payment doesn't happen and your previous agreement starts turning into a dispute over what is owed, you may need to consider what legal avenues are open to you to get your money back. The success of any legal action will then depend on what evidence you can provide to show that the debt is owed. The burden of proof will be on you as the claimant to show that the amount you're claiming is due. Court should be your last resort in attempting to recover your money, and so you should be confident that you have a strong case, sufficient evidence, and follow the set pre-action procedure prior to issuing a claim. The experts here at Middlebrooks Advice are well able to assist in ensuring that the proper process is followed. In the absence of a written contract or agreement being in place, there are various other pieces of information that you may be able to secure which can provide evidence that the money is due. Whilst the use of cheques is diminishing, hundreds of millions of cheques are still issued every year. If your debtor has sent you a cheque that has bounced or agreed to a direct debit that has been returned, it is often all the evidence you need to prove a debt is owed. In law, a cheque is considered a promise to pay, so it can be used as a clear admission that money is due. It is not uncommon for a business to invoice without a contract. Most businesses use invoices to request payment, so providing copies and proof of them being issued to a customer or supplier will go a long way in proving that a debt is owed, even if they aren't directly attached to terms of business or a contract. Furthermore, if you provided regular statements of the amounts owed and showing overdue, then these will also be useful as evidence. Once payment is overdue, you will have hopefully contacted the person or company to chase the debt. Emails, letters, texts, or messages exchanged on social media can all be used to help prove a debt is owed and overdue. If the other party has responded to you, apologising or asking for more time, then this admission will be extremely valuable in proving that they don't dispute that they are actually owing the debt. So it's important that you save or screenshot these messages in the event that they are needed. Without a written agreement, there should still be plenty of information that you can pull together to prove what you're owed. However, if the other party disputes the amount or that any debt is owed at all, then you may have a fight on your hands that needs to be settled in court. It will then be down to the evidence you can gather and how your claim is presented to convince a judge that you are entitled to the money owed in the absence of a legally binding contract. So getting the experts here at Middlebrooks involved at an early stage can assist in recovering this debt. Please don't hesitate to get in touch with us.